Hello viewers, how are you all doing today? Let's delve into another fascinating topic from our course Economics and Law 1, which pertains to environmental laws. The title of our discussion today is Economic Analysis of Environmental Laws 1. Economic analysis of environmental law is an interdisciplinary approach to understanding, evaluating, and improving environmental protection legislative frameworks using economic ideas and methodology. This discipline applies concepts from environmental economics, legal theory, and policy analysis to solve major concerns including climate change, resource depletion, and pollution. The core idea is that environmental rules may be tailored to promote both ecological sustainability and economic efficiency, ensuring that limited resources are put to the greatest possible use. Environmental issues are frequently caused by market failures in which private costs and benefits do not correspond to social costs and benefits. For example, a manufacturer may release toxins into a river without bearing full responsibility for the resulting damage to downstream consumers. This results in an externality, which is a cost imposed on third parties that is not accounted for in the pricing process. Economic analysis exposes such inefficiencies and provides instruments for internalizing externalities, ensuring that those who cause environmental harm bear the costs of mitigation or prevention. Another important notion is the tragedy of the commons, popularized by Garrett Hardin, which depicts the exploitation of communal resources including air, water, and forests. In the absence of defined property rights or governmental control, people act selfishly, resulting in resource depletion and environmental deterioration. Economic analysis provides frameworks for addressing these issues using processes such as property rights, market-based tools, and collective action tactics. Economic analysis employs various methodologies to assess environmental laws and policies. These includes, the first one is cost-benefit analysis. The cost-benefit analysis entails weighing the cost of enacting environmental legislation against the expected benefits such as lower pollution or better public health. For example, the expenses of enforcing emission rules for industry can be offset by the health advantages of cleaner air. Next is market mechanism. Carbon pricing, tradable pollution permits, and environmental levies are examined for their ability to reduce pollution at lowest feasible cost. Third is behavioral economics. Human behavior insights are utilized to create policies that promote compliance and sustainability. For example, giving subsidies for renewable energy adoption might encourage individuals and businesses to abandon fossil fuels. The primary objective of economic analysis in environmental law are: first is efficiency, ensuring that environmental rules achieve their objectives while incurring minimum economic costs. For example, an effective law would minimize pollution while avoiding unnecessary taxes on industry. Second is equity, balancing the distributional effects of environmental regulations, especially in developing nations such as India, where marginalized people are sometimes disproportionately affected by environmental deterioration. The third is sustainability, promoting long-term protection of natural resources and ecological services while fostering economic growth. Despite its potential, economic analysis of environmental laws face several challenges. Like, first one is valuation of environmental goods. Placing monetary prices on non-market commodities such as clean air, biodiversity, and scenic beauty is inherently difficult and contentious. Second, uncertainty and complexity. Environmental systems are complex and dynamic, making it difficult to forecast the long-term effects of actions. Third, ethical considerations. Reducing environmental challenges to economic terms can sometimes obscure ethical and cultural components such as the inherent worth of nature. So, India's environmental concerns are numerous, resulting from growing industrialization, urbanization, and population increase. The country is dealing with difficulties like air and water pollution, deforestation, and climate change, all of which have substantial economic impacts. The Indian legal framework for environmental preservation is comprehensive, including constitutional provisions, statutory legislations, and judicial precedents. The directive principle of state policy under Article 48A and fundamental duties under Article 51AG prioritizes environmental conservation. Laws such as the Environmental Protection Act of 1986 and the Air and Water Acts offer statutory support, while judicial activism has played an important role in enforcing environmental standards. Economic analysis provides useful insights for increasing the efficacy of this legislation. For example, India's dependence on command and control methods such as set emission regulations might be supplemented with market-based tools like carbon pricing or tradable pollution permits to encourage compliance and innovation. Now let's talk about environmental economics. Core principles and theories. So, environmental economics is concerned with understanding how economic concepts and methods may be used to address environmental issues, with an emphasis on the relationship between ecological sustainability and economic efficiency. At its heart is the idea of externalities, which refers to the unintentional repercussions of economic activity that harm third parties. For example, pollution from industrial activity imposes costs on society, such as health problems or lower agricultural yields, that are not represented in the market pricing of items produced. This imbalance causes market failure, in which market fails to efficiently allocate resources, necessitating government intervention. Another fundamental idea is the tragedy of the commons, coined by Garrett Hardin in 1968. It emphasizes the overexploitation of communal resources such as forests, fisheries, and clean air, when individuals choose personal gain over collective well-being. In India, instances such as overgrazing of common grasslands and groundwater depletion demonstrate the theory's significance. To address these difficulties, economic policies frequently suggest remedies such as property rights, community management, or governmental control. Public goods are closely related to the tragedy of the commons. Environmental resources such as biodiversity and climate stability are non-excludable and non-rivalrous, which means that no one can be denied their advantages, and one person's usage does not deplete their availability for others. However, this frequently results in free riding, in which people or organizations gain from environmental conservation efforts without contributing to them. Carbon taxes and payments for ecosystem services are examples of economic devices that aim to close these inequalities by internalizing environmental costs. Another important idea in environmental economics is the concept of sustainable development, which aims to balance economic growth with environmental conservation. The Brundtland Report in 1987 popularized the concept of sustainable development, which emphasizes fulfilling current demands without jeopardizing future generations' capacity to meet their own. This idea is particularly important in India, where fast industrialization and urbanization frequently result in environmental deterioration. Policies supporting renewable energy, waste management, and green infrastructure are in line with the Sustainable Development Framework. The green economy arose as an extension of sustainable development, advocating for economic systems that prioritizes environmental well-being. In India, initiatives such as the National Solar Mission and afforestation projects run by CAMPA, that is Compensatory Afforestation Management and Planning Authority, represent efforts to transition to a green economy. These efforts seek to divorce economic expansion from environmental degradation by promoting companies that create jobs while preserving resources. A major difficulty in environmental economics is valuing environmental resources, which entails assigning monetary value to intangible benefits generated from ecosystems. These include both use values such as the immediate advantage of clean water or lumber, and non-use values such as the intrinsic value of protecting endangered species. Policymakers can justify conservation project spending using techniques such as contingent value and hedonic pricing. For example, the economic value of mangroves along India's coastlines highlights their important role in safeguarding populations from storms and floods, encouraging initiatives to preserve them. Economic theories also emphasize the significance of policy tools for resolving environmental challenges. These devices are essentially divided into two types: market-based mechanism and command and control techniques. Market-based solutions such as tradable pollution permits seek to encourage industry to decrease emissions by assigning monetary value to pollution rights. Command and control tactics such as emission standards and regulatory fines achieve compliance by issuing direct mandate. In India, tools such as the Perform, Achieve and Trade initiative, which is part of the National Action Plan on Climate Change, exemplify how these ideas are applied. Finally, the use of behavioral economics in environmental decision making is gaining traction. Understanding human behavior, such as preferences for short-term profits over long-term advantages, can aid in the development of policies that encourage individuals and organizations to adopt sustainable practices. Initiatives like promoting energy-efficient appliances and eliminating single-use plastics employ behavioral insights to encourage change. Environmental economics provides a solid foundation for studying and managing the complex interactions between human activities and natural systems. It offers practical insights for developing policies that promote sustainable development and ecological resilience by including ideas such as externalities, market failures, and resource pricing. Now let's talk about the legal framework for environmental protection in India. India has a strong legal framework to protect the environment, which is entrenched in the Constitution and has been strengthened via a succession of legislative and judicial initiatives. The Indian Constitution establishes the framework for environmental conservation, recognizing it as both a sovereign obligation and a basic duty of citizens. Article 48A of the Directive Principles of State Policy requires the state to maintain and develop the environment as well as preserve forests and animals. Similarly, Article 51AG emphasizes every citizen's essential responsibility to maintain and develop the natural environment, which includes woods, lakes, rivers and animals. These laws reinforce the constitutional commitment to a clean and healthy environment. In addition to constitutional duties, India has passed numerous significant environmental laws to address specific challenges. The Environmental Protection Act of 1986 is an umbrella piece of law that provides a framework for coordinating environmental policy and regulating actions that affect the environment. This legislation, enacted in the aftermath of the Bhopal gas tragedy, authorizes the central government to adopt environmental protection measures such as setting emission limits, regulating dangerous chemicals, and prohibiting polluting enterprises. The Air Prevention and Control of Pollution Act of 1981 and the Water Prevention and Control of Pollution Act of 1974 both addresses air and water pollution. These laws create national and state pollution control boards, which are in charge of monitoring compliance, issuing clearances, and implementing corrective actions. Industries must comply with the standards established by these bodies, making the regulations an important part of India's environmental governance. Similarly, the Forest Conservation Act of 1980 aims to prevent deforestation by limiting the use of forest land for non-forest activities. This act demonstrates India's dedication to balancing development goals with environmental conservation. Another important component of India's environmental law is the Environmental Impact Assessment, which was implemented under the Environmental Protection Act. Before a project may be authorized, the EIA requires developers to analyze and minimize its possible environmental effect. While this procedure strives to assure long-term growth, it has been criticized for implementation issues such as claimed dilution of rules and minimal public input. India's judiciary has played an important role in establishing the environmental law system. frequently stepping in to fill legislative and administrative gaps. The doctrine of sustainable development, public trust, and the precautionary principle have all been recognized and implemented by the courts in key decisions. For example, in MC Mehta versus Union of India, the Supreme Court emphasized the importance of environmental preservation by holding companies responsible for pollution. The court also established the notion of absolute responsibility, which requires companies that engage in dangerous operations to pay victims regardless of wrongdoing. Public interest litigations, commonly known as PILs, have helped to democratize environmental justice by allowing people and non-governmental organizations to seek court involvement in environmental issues. Specialized courts such as the National Green Tribunal were formed under the National Green Tribunal Act of 2010 to speed up the settlement of environmental issues. The NGT has the jurisdiction to hear cases involving environmental preservation, forest conservation, and the enforcement of environmental rights. Its founding was an important step towards securing access to justice for environmental disputes. Despite these legislative and judicial initiatives, obstacles remain in the implementation of environmental legislation. Issues such as bureaucratic inefficiency, a lack of resources, and political intervention frequently impede efficient implementation. Furthermore, reconciling environmental preservation with India's economic growth goals remain a difficult challenge. Programs like the Clean India Mission, Swachh Bharat Abhiyan, and the Namami Gange project demonstrate the government's efforts to reconcile environmental aims with larger socio-economic goals. To summarize, India's legal system for environmental preservation is broad, including constitutional mandates, legislative measures, and judicial precedents. However, increasing enforcement mechanism, raising public awareness, and incorporating technical solutions are crucial for addressing rising environmental concerns and achieving sustainable development. Now let's move on to our next topic, that is economic tools in Indian environmental governance. Economic instruments play an important part in India's environmental governance with the goal of striking a balance between economic growth and sustainable development. These strategies, based on environmental economic concepts, assist in internalizing the externalities generated by environmental degradation and guarantee that the polluter suffers the cost of pollution. As India faces severe environmental difficulties such as air and water pollution, deforestation, and waste management, the use of economic tools has become increasingly important in developing policies that balance environmental goals with financial incentives. One of the most visible economic instruments in India's environmental governance is the Pollution Control Board regulatory framework, which incorporates economic considerations into compliance processes. The Central Pollution Control Board and state pollution control boards perform crucial roles in enforcing pollution standards and imposing fines for non-compliance. While command and control tactics have traditionally been used, there has been a progressive trend towards market-based techniques such as levying penalties and fees to represent the environmental costs of industrial operations. For example, SPCBs have established water cess and effluent charges to restrict industrial discharge into rivers with the goal of ensuring the polluters pay for the expenses of cleaning and preserving water quality. The environmental impact assessment is another important economic instrument for influencing project approvals and reducing possible environmental damage. Established by the Environmental Protection Act of 1986, EIA framework requires a detailed review of proposed projects, evaluating economic advantages against environmental costs. While the EIA process has been criticized for delays and enforcement gaps, it remains an important vehicle for incorporating economic considerations into environmental decision making. The inclusion of public consultations and socio-economic impact assessments emphasizes the interaction of environmental and economic concerns in India development initiatives. India has also experimented with market-based approaches to environmental concerns. The notion of transferable pollution licenses, which was implemented through pilot projects, represents such initiatives. For example, the Gujarat Emissions Trading Scheme for particulate matter is a cutting-edge project that reduces industrial emissions using a market-driven model. This cap and trade mechanism enable companies to purchase and sell emission permits, incentivizing cost-effective pollution control methods while remaining within overall emission limitations. Although still in its early stages, the success of such initiatives in India may open the way for further acceptance of market-based solutions in other industries. Taxation and subsidies have also acquired traction in Indian environmental governance. Green taxes such as the coal cess implemented in 2010, later renamed as the GST compensation cess on coal, are intended to discourage the use of ecologically detrimental resources while also raising funds for renewable energy initiatives. Similarly, subsidies for solar energy, electric vehicle and energy efficient appliances through programs such as the National Solar Mission and FAME India, that is faster adoption and manufacturing of hybrid and electric vehicles, aim to promote sustainable practices by easing the financial burden on consumers and producers who adopt green technologies. India's emphasis on corporate social responsibility exemplifies the incorporation of economic methods into environmental policy. Under the Companies Act of 2013, enterprises that satisfy certain financial conditions are obligated to spend at least 2% of their average net profit on CSR operations, which frequently include environmental initiatives. This clause has encouraged firms to participate in renewable energy, waste management, afforestation and water conservation projects, integrating private sector interests with public environmental aims. CSR programs not only complement government efforts but also foster a culture of business accountability in addressing environmental problems. Public-private partnerships are another economic mechanism used to solve environmental issues in India. PPPs have played an important role in initiatives including waste-to-energy plants, municipal water waste management, and renewable energy generation. For example, the Clean Ganga project used PPP methods to build and operate sewage treatment plants, combining public investment with private sector efficiency to clean up waterways. These collaborations promote improved resource allocation, risk sharing, and innovation for addressing environmental concerns. Despite these advancements, the use of economic techniques in Indian environmental governance presents considerable problems. Weak enforcement procedures, poor pollutant data, and industry resistance impede the efficient use of these instruments. For example, while fines for environmental infraction exists, their deterrent impact is frequently undermined by insufficient monitoring and delayed sanctions. Similarly, the promise of market-based mechanisms such as carbon trading and green bonds goes untapped due to a lack of institutional capacity and clear legal frameworks. The emergence of green finance structures such as sovereign green bonds and environmental funds presents potential prospects for strengthening economic tools in India's environmental policy. The Reserve Bank of India's inclusion of renewable energy in its priority sector lending criteria demonstrate a rising emphasis on allocating financial resources to sustainable development. Green financing may help to fund large-scale renewable energy projects, urban infrastructure renovation, and climate resilience measures by leveraging private funds and foreign investments. India's reliance on economic methods for environmental governance emphasizes the significance of developing policies that strike a balance between environmental preservation and economic growth. The effectiveness of these techniques is determined by their capacity to incentivize compliance, minimize pollution, control costs, and foster innovation in green technology. Learning from foreign best practices such as the European Union's emission trading system or Canada's carbon pricing schemes can improve the efficacy of economic tools in India. Furthermore, increasing stakeholder understanding and engagement, including industry, civil society, and local communities, is crucial to guaranteeing environmental governance, long-term visibility, and inclusion. So, to conclude, economic instruments are an important part of India's environmental governance system. They not only offer a practical solution to environmental issues, but they also promote the effective allocation of resources towards sustainable growth. By improving these instruments and eliminating implementation gaps, India can fulfill its environmental goals while also promoting economic growth, creating a precedent for other developing countries to follow. With this, we come to the end of our today's lecture. Thank you very much.